Today we are going to discuss Chapter 12, Section 154 to Section 176. Name of the chapter is Information to the Police and Investigation by Police. So this chapter of CRPC, it focuses upon information to the police and investigation thereon. This chapter talks about 8 topics. It could be divided into 8 topics. The first is First Information Report, Section 154. Second, Information in respect of non-cognizable offences, Section 155. Third, Powers of Investigation, Section 156 to 159. Attendance and interrogation of witnesses, Section 160 to Section 163. Then confession, Section 164. Then search by police officers, Section 165, Section 166. Then letter of request, Section 166A and 166B. And last topic is other provisions regarding investigation, which runs from Section 167 to Section 176. We will be dealing with these topics one by one. Now, the first topic which we are going to deal today is Section 154, Information in Cognizable Cases. Now, once offence has been committed, the criminal law will set in motion on receiving the information about the offence. So once information about the offence is received, then criminal law will be set in motion. The flowchart and definitions are already being discussed in previous videos. Section 154 head note says information in cognizable cases, and famously this is known as First Information Report, FIR, First Information Report. That is the first information received by a police officer in charge of station revealing commission of cognizable offence on which the investigation may be commenced. So what is the fundamental and main thing here is that the information shall reveal commission of cognizable offence. Something must be there in that information which reveals that yes, a cognizable offence has taken place or is going on which the investigation may be commenced. In previous videos we have seen that investigation may be commenced in cognizable cases only. Section 154 clause 1, it talks that information shall be in writing. The FIR received, it shall be in writing. If it is given oral, then police would reduce it in writing and shall read over it to informant. Secondly, the information shall be signed by the defendant. The information shall be signed by the informant, not defendant. The information shall be signed by the informant. Third, substance of such information is to be recorded in general diary or station diary. A diary is kept in every police station. So whatever thing is happening throughout the day in the police station, it is being recorded in general diary, also known as station diary. Then Section 154 clause 2 says the copy of information so received, that is FIR or reduced to writing, shall be given to informant, meaning thereby copy of FIR shall be given to informant. So we can change the language here. The copy of FIR shall be given to informant. Section 154 clause 3, it says if police officer in charge refuses to lodge or file the FIR, then informant may approach to SP through post. He will post his complaint to SP of that district. Then if SP is satisfied from the information, he will order to file FIR. He will order to police officer to file the FIR. Now the next subtopic is threefold object of Section 154. In other words, threefold object of FIR. First is to inform that a district SP about the offense, as he is responsible for maintaining peace and security. What is happening in the area has to be informed to senior officials. Second, once FIR is lodged, there cannot be further changes made to it. Hence, it protects the accused from further variations and additions. The third object is to inform the judicial magistrate who may try the case about the material and substance over which investigation is commenced. This requirement is done as per Section 157. On the basis of information, magistrate would take action as per Section 159. Now let us see what the Section 157 and 159 talks about. So head note of Section 157 is procedure for investigation. So Section 157 requires police to submit report to magistrate, the concerned magistrate. Now Section 157 clause 1, police would send a report to magistrate about the FIR and actions taken so far. And as per Section 157(1) subclause B, if police officer does not find sufficient ground for entering on an investigation, he will not investigate the case. He will refrain himself from investigation. Now Section 159, what does it says? It says that if police officer has decided not to investigate as per Section 157 clause 1 subclause B, and it appears to magistrate that police is neglecting its duties, then magistrate may order police to investigate. He will order the police that you investigate the matter. Alternatively, further, the section also allows magistrate that he may launch a pre-inquiry after receiving police report to be conducted by magistrate subordinate to him to dig out the truth of the substance of offense. So either he may hold a pre-inquiry or he may order the police to investigate the matter, and this has been stated under Section 159. Now some important points as to FIR. First, it should be the information of fact. It should be the information of fact disclosing commission of cognizable offense, as we did earlier also. Any person may be informant. It is not required that victim has to be informant. The information of commission of cognizable offense can be given by any person. He may be victim, he may be eyewitness, or whoever it may be. However, in few cases, information given by a victim is desired and has consequences. For example, Section 8 illustration J and K of Indian Evidence Act 1872, where it requires that if a woman has been ravished and if a person is robbed and soon after being ravished or being robbed they file FIR as per illustration J and K respectively, which is stated here, then that would constitute relevant conduct as per section 8. So section 8 also talks about conduct. So losing information in these two circumstances would state the conduct of accused, which is a circumstantial evidence. Moving further, statements given after FIR or after commencement of investigation does not amount to FIR. Then sharing of information by one police officer to another regarding possible commission of dacoity is not FIR. But if information is given from point of view of launching the investigation, then it would be FIR. Police themselves share information, they have their informants, but in all the cases they don't go to for lodging FIR, but they use the information to stop the activity. However, if activity is there, then FIR would be lodged. But the purpose of this point is that the internal information of police does not amount to FIR per se. Then the information received on telephone, if may reveal fact of commission of cognizable offence, may amount to FIR. However, it has to be reduced to writing by a station writer and may act as informant, and this station writer may act as informant. It is kind of a typical or slang term, but it means the person who is receiving the call and getting the information. Then if place of offence is not known, then police cannot refuse to lodge FIR. For example, Mr. A is traveling in metro, and when he get out of his last station, he found that his purse is not with him. He has lost it somewhere. So now he has passed 4 metro stations in different areas. Which police station is empowered to lodge the FIR? So in such cases, all the police stations are empowered, and the person Mr. A may get his FIR lodged in any of the police station. Such FIR is known as zero FIR. Such FIR is known as zero FIR. Then counter FIR, sometimes known as cross FIR. It is also termed as cross FIR, counter FIR. It means when one party makes FIR against second party and second party makes FIR against first party, then it would be termed as counter or cross FIR. Generally, weightage is given to first FIR. However, police club both the FIR and investigate the matter accordingly. Now, evidentiary value of FIR. Evidentiary value of FIR. FIR is not a substantive piece of evidence. It is usually preferred by prosecution to strengthen the case by means of corroboration, etc. FIR is used for limited purpose, like for corroboration as per Section 157 Evidence Act, for contradiction as per Section 145, to show conduct under illustration J and K of Section 8, which we just discussed, FIR may be treated as dying declaration under Section 32 Clause 1. It may be used to check the veracity of prosecution case under Section 11 of Evidence Act. Now, delay in lodging FIR. The purpose of early information is to record the circumstances before they are forgotten or embellished. Prompt lodging of FIR results in diminishing the chances of false implication and informant being tutored. Now, delay in lodging FIR may be fatal for prosecution case as it is a question mark. It reveals the intention and allows to raise finger over authenticity of FIR and activities of police. Delay in lodging FIR may not be fatal if reasonable grounds are there, like opting wrong police station or honor of family in case of rape cases, or informant was in shock after witnessing the event. It is to be noted that there is no formula by which inference can be drawn as to authenticity of FIR. It is to be done by application of judicial mind over the facts, circumstances, and tools like corroboration and contradiction as provided by law. So over these principles it would be ascertained whether FIR is authentic or not. However, the court will look in all the facts and circumstances, the corroboration, testimony, other statements, and even a weak FIR may lead to a relevant trial and case. So this is for this video only. We'll deal with next topic in next video, next part. If you have any question or any discussion, you may put it in comment box. Stay safe, stay healthy. Thank you.